What exactly is common law? You'll have heard the term used with increasing frequency over the last few years, particularly on social media, often in conjunction with statements such as "I stand under common law, not maritime law," or "I don't consent to be governed, I stand under common law," and so on. You may also have heard of the terms common law nuisance or common law agency, common law partner, which doesn't really exist, by the way, all of which are derived from a concept which I'm going to explain in this video. But first of all, if you're new to me, I'm a barrister who helps you understand law on this channel, so please subscribe and hit the bell icon so you don't miss out on anything. So in order to explain common law properly, I'm going to have to give you a very brief overview of the legal system in the United Kingdom, that being England, Wales, Scotland and Northern Ireland. Unlike the United States of America, the United Kingdom does not have a single document setting out a written constitution. The United Kingdom does not have a single document setting out written rights of the individual and the way that a government is supposed to act. Instead, the UK Constitution is derived from a number of different sources, some of them written, such as statutes, but others constitutional conventions which are not written. The UK has a parliamentary system of governance, with the Westminster Parliament being the supreme lawmaking body. In other words, this means that the courts will accept that the legislation enacted by Westminster Parliament is superior over common law, which is sort of the point of this video. The UK Parliament is made up of two houses, the House of Commons and the House of Lords. The House of Commons being a representative party, in other words its members are elected, whereas the House of Lords is not a representative body, is not elected and is mostly made up of life peers, or some of which are appointed as peers. And together with the head of state, known as the monarch, currently Her Majesty Queen Elizabeth II, the House of Commons and the House of Lords make up the legislative branch, whereas the monarch, Prime Minister, other ministers and police and armed forces make up the executive branch. And finally, the judicial branch comprises also of the monarch, but also judges and magistrates. And whilst there is no formal separation of powers within the UK, it is quite easy to separate the persons within each of the branches. So if Parliament is creating law by written legislation, where does common law come into all of this, and what does common law actually mean? This is where the judicial branch comes into play. Through a series of checks and balances, the judiciary will ensure the residual freedoms of individuals, look at any act taken by the state. It is there to resolve disputes and ensure the right to a fair trial and a fair hearing. Even the principle of habeas corpus, which is individual liberty. The courts can review any decision to detain an individual, although this is now also contained within ECHR. And by creating judgments in individual cases based on individual sets of facts, the courts create a hierarchical body of decisions known as common law. And this is why there are many different areas of law that are prepended with the term common law. For example, common law nuisance. They will be a collection of judgments which set precedents, principles and rules upon which future cases will be decided. Hence the term common law, because this helps lawyers and individuals to understand how a certain area of law is applied in any given set of facts. Now, of course, in some cases there may be statutory or written legislation to provide for such areas. For example, the Occupier's Liability Acts of 1957 and 1984 deal with different elements of a property and the owner or occupier's duty to make that property reasonably safe for guests and even trespassers, whereas many of the more finer points will be decided in case law. For example, coming back to common law nuisance, the occupier of land has a general duty to his neighbour for any hazard occurring on that land, whether or not it is a naturally occurring hazard or a man-made one. And this was set out in Leakey and the National Trust of 1981. And that is refined further still in that the standard of that duty of care expected of the occupier is to be that which is reasonably required of him in his particular circumstances. And that was a principle set out in Goldman and Hargrave of 1967. And there are some situations that legislation just cannot possibly foresee. For example, Japanese knotweed. In such a situation, legislation had not taken into account such an invasive species, and when the facts came before a court, it had to make a decision as to whether this could amount to nuisance. In particular, where there was no physical damage, whereas it had degraded the value of the property. This was in the case of Williams and Network Rail of 2017. You may also be forgiven for thinking that the Homicide Act of 1957 is everything to do about murder. However, this remains a common law offence, and this act merely reformed the offence. In fact, there are many offences that remain as common law offences to this day. There are also defences that are common law defences, including that of self-defence. So self-defence is a common law self-defence. If you want to hear more about self-defence, I have 1 or 2 videos linked below. So you can imagine my concern when I saw some videos on TikTok just recently where someone is saying that you can just renounce all legislation, state that you stand under common law and none of the legislation applies to you, including things such as council tax and so on. These types of video are dangerously misleading, and I strongly urge you not to even watch them and certainly not to take them into account. Even on this video, I repeatedly tell you that my videos cannot be legal advice to you because I am not advising you on individual facts and circumstances as a court would decide if a case comes to court. In these videos, I can only explain to you broad outlines and guidelines as to how the law works and applies in standard form. So if you see such videos and you remain unsure, please seek formal legal advice. If you want to read more about how common law has developed over recent years, including offences, defences, nuisance and so on, I will put some links in the description below to books that I find particularly useful. In the meantime, I hope that was a useful, if brief, overview of how common law integrates with the legal system of England, Wales, Scotland and Northern Ireland. So please give this video a thumbs up if you found it useful, and remember, stay humble and subscribe.